If you could give me your name and where you're from.
David Morris, I'm the Chief Executive Officer at the Environmental Defenders Office, New South Wales.
David, we're here in front of the Land and Environment Court, and you've joined the case for the Wallarah 2 coal mine. Why have you and the office done that?
So the Environmental Defenders Office is here today representing ACA, which is opposing the development of the Wallarah 2 coal project. And the reason that we're representing them, we're a community legal service that specialises in environmental and planning law, and we act for people who are seeking to use the law to protect the environment in the public interest, and this is clearly an example of that.
It must be a competitive case to have your office represent a community. Why particularly have you prioritised this particular case?
Sure. So our office takes a very thorough assessment of all cases that are going to put substantial resource pressure on our office. The Wallarah 2 project is quite an extraordinary project when you look at the iterations of it that have been going on for a number of years now, and the potential impacts that it has both in terms of greenhouse gas emissions and the contribution to greenhouse gas emissions, but also the potential threat to the Central Coast water supply, and the rather extraordinary measures that are included in the development consent, which require potential acquisition in the future to deal with water loss to private property owners, but also to the Central Coast water supply. So we thought that taken as a whole, this is a case of really great significance with huge public interest elements.
Alan Hayes has pointed to a defence that you may be running in intergenerational equity. Could you explain to us what that's all about?
There's some really technical arguments. We're running 10 grounds. We are running some grounds which relate to how the Planning Assessment Commission dealt with the contribution this mine will make to greenhouse gas emissions. And we're looking at the process of consideration that the PAC undertook when considering downstream, particularly downstream emissions to the mine, and we say that the way they undertook that consideration, or if there was a consideration at all, that was not in accordance with the law.
So what do you think your or the community's chances are in this particular court case?
So the EDO doesn't bring proceedings to court unless we believe they have reasonable prospects of success. Reasonable prospects of success, of course, doesn't mean that you're a lay-down misere to win. It just means that, as it says, you have a reasonable case to be argued. We certainly think there are some very strong points that we'll be raising with the court over the next 4 days, and obviously from our client's perspective, they're very hopeful that we get up on those grounds.
How long do you expect the court case to go, and the decisions, more importantly, how long will the deliberations take before we have a decision?
So the court case is listed for 4 days. It's unclear whether it will run for the full 4 days. I suspect that it will. There's 10 grounds. There's a high degree of complexity in relation to some of those grounds. In terms of how long the judgment might take, that's even more difficult to answer. There is no particular time frame within which the judge has to grapple with the issues and return a judgment, but quite often it could be a matter of months before we know the outcome of this proceeding.
All right, thank you for the interview.
Pleasure, thank you.